Hello. Hi, everyone. This is Alex. And today, Andrea Gorrie of Trademarkia is joining us. Hi, Andrea. How are you doing?
Hi, I'm great. How are you?
Fine, fine. Thanks. So I'm in Warsaw, Poland, and you are
I'm in Los Angeles, California.
wonderful. What's the weather like?
Amazing. I can never have any complaints about it. It's about like 70 something every single day. So never hot, never cold. So consistent.
That is something to be desired. Andrea, so listen, I have some questions about copyright and trademark protection, and how about we just jump right in? I have a series of questions.
Mhm.
And so, what is a trademark and why is it important for my business, for anyone's business?
Sure. Yeah, the reason a trademark is important is because as you know, it's intellectual property. So really it's a property asset for your business. I think one of the biggest misconceptions about trademarks is that, it's something you just file on its own and then, you own it, and that's really it. Really, getting a trademark is a lengthy process, and the importance of it really comes from how you can use it. A trademark allows you to stop people from infringing on your brand, and that a brand can be a lot of different things. It doesn't have to just be your name as a company. It can be a name, though. It can also be a logo. So really any sort of designs that people associate with your branding, slogans. It can even be things like colors and sounds. I can think of some really famous examples that are really niche, but for the majority of people, we're really just looking at the name of your brand that consumers recognize and your logos. So a trademark can allow you to prevent other people from infringing on those rights. So if another person's copying your name or copying your logo in connection with whatever you're doing under your business. So if you're selling a certain type of good or you're performing a certain type of service under your trademark, if someone's ripping that off, essentially, that's what having a trademark registered allows you to do. It gives you a leg up in court to stop other people from doing so. Um, you can also use it, yeah, a bit more defensively. So if someone else tries to claim that you're infringing on them, but if they don't have a registration, you can use that to your advantage and say, well, I have the registration to it, and that grants me the priority in the corresponding country that you filed in.
So, am I correct in assuming that we're talking about an entry in a United States of America, an American register of trademarks?
Yeah, and I think that's another thing is that most people don't understand that a trademark it's all about what country you're filing in. So when I file for a trademark in the United States, it's only for the United States. And so technically, that grants me no protection for the opposite side of the world. Someone could completely rip me off, and there's not a lot of protection that I have because my trademark is only in that country. And so that kind of gets into, I think one of our next questions, which is country-specific filings. So in general, your trademark is only protecting you in the country that you have your filing in. So lots of people, when they know that they're conducting business in foreign countries and they have a large, customer base in those other countries, they will file in those countries specifically to grant them the protection that a trademark offers them in that country.
Does does the USA have any treaties with any neighboring countries or otherwise that would allow for mutual recognition of trademarks?
Yeah, so most countries are, I mean, most of them, the main countries that we can think of off the top of our head are members of treaties that allow for, easier filings between them. For example, if I filed in the US now or filed in another country beforehand, you can file in another country and then claim priority on your application to that previous foreign filing, and allows you to maintain consistency between your applications. It also, just creates consistency in your trademark portfolio in general, and it also maintains priority among your trademarks. So for most systems, a really important date to keep in mind for your trademarks is what's called the priority date. So when I file a trademark in at the USPTO, so in the United States, I get a priority date on that application of the date I file. So that means that my priority to that trademark is established at the time I'm filing that trademark, not just when I get the registration. So let's say I decided also I'm going to file in Canada because I know I have a lot of customers in Canada. If I file in Canada, I don't have to just get a brand new priority date in Canada because that would kind of put my rights back a bit because I'm filing later. The nice thing is that because Canada and the United States are treaty members, I can claim on my Canadian application priority back to my United States filing. And so it keeps a chain of continuity between my filings. And so you don't really have to reestablish your priority to marks in other countries. It can predate back to your US filing.
Are there any countries that the USA shares such a good relation in this respect to as Canada, maybe Japan, Mexico?
Yeah, most of the most major IPOs, intellectual property offices. So really the bulk of the filings I see and, go very smoothly with this kind of process are, Canada, Mexico, European office. We have Japan, UAE, we do filings there as well. So really any country you can think of, pretty much you can file in. They all, of course, examine completely independently and all have their own process, but most of them use, the same international classes and allow you to, establish your priority based on other applications or registrations as well.
Indeed. So moving on exactly to the next question, which is what is the process for registering a trademark?
Yeah, so unfortunately, it's a bit more complicated than I think a lot of people have that conception of. It's not just that, you pay some money and then you own a trademark that no one else has. Um, of course, if it was that easy, we wouldn't need attorneys for it. And so it gives me a job. But in general, when you file a trademark at the USPTO, for example, and a lot of other, intellectual property offices, but I'll just stick to the US for, simplicity. When you file a trademark at the US, you let them know what your trademark is. So you would say, what, is this a name that you're filing for, your brand name, or is this a logo? You also have to pick what's called a class. And so classes are actually international classes, which means that most countries that that you're going to be dealing with follow the same class schema. So let's say, for example, I had a brand name and I was going to file for that brand name for clothing. I wanted to sell t-shirts and hats, as I have a lot of clients that sell clothing. You pick a class that corresponds for the goods you're selling. In this case, that would be class 25 for clothing. So I would let the USPTO know, here's my brand name and here's the class that I want to file in for the goods I'm going to sell, which is class 25 for clothing. On top of that, you also need to say who owns the mark. Let's say I'm a new business owner and I'm just operating everything personally. So I'm just going to have myself be the owner. Andrea, I'm the owner of this trademark. You let the USPTO know that. And then the last part is really whether or not I've started using this mark in commerce or not. So let's say I haven't even sold a single product yet. I don't have any idea how I'm going to do it. I haven't contacted any manufacturers to sell my t-shirts or anything. So what I would then tell the USPTO on the application is that I have an intent to use this trademark in commerce. That's one of the two main filing bases of an application. You're either going to say this is intent to use or in use. And so for an intent to use application, that just means I haven't started using the mark in commerce yet, but I have a really good intent to do so and I plan on it. And so I don't have to say anything else on the application. Then we file and then we wait. The USPTO does take quite a while for trademark applications to process. The majority of the time, it's just sitting in a queue. Once you file, right now, turnaround time, it's about a year-long registration process. The majority of the time, it is just sitting there, though. The actual examination and correspondence you may have with the USPTO only takes a couple months, but it really depends on the circumstances.
Is there any way to speed this up?
There's a few ways. The main way when I point out the way to expedite the process is when you have a past registration. But if you're just filing for the first time with a brand new trademark that's never been registered before, in general, it does have to go in the normal queue with the normal timeline. If there is some sort of like extenuating circumstance, I'm really thinking like someone's about to die or, your business is in jeopardy, maybe. In general, though, you feeling an urgency about getting your trademark rights isn't enough, and it just has to wait in the normal queue.
So am I correct in assuming this is the Nice Treaty that sets the classes that are to be applied?
Yep, and they designate these international classes. So basically, they say IC and then their number, which corresponds to what goods or services you're filing for under your trademark. There are also like US classes, but really those are less important to pay attention to because they just correspond to those international classes. And the international classes are the ones you really designate on your application.
Could you say that you see the most action in your section of the business in a specific field, in a specific class, or one that you specialize in?
Yeah, the majority of my clients are usually e-commerce sellers, and so this is going to be anyone who's selling on their own website or on Amazon or really selling someone else's products, drop shippers, things like that. And so the majority of the time, what I'm filing in is actually class 35 for online or physical retail store services. And so a lot of people opt to file in this class because they might not know exactly what they're going to sell in its entirety. They might sell a giant laundry list of goods. They might sell clothing, they might sell sporting equipment, they might sell bags. And so all of those goods on their own fall into various different classes. But if I file for online retail store services, I'm filing for that as a service, and I can claim all of those goods within my service of online retail. And so that's usually where I'm at is helping people with their, their e-commerce and in that class respectively.
If I see, because in commercials and advertising, in print, I'll see a small the letters T and M next to a brand name, or I'll see an R in a circle. So one's registered, the other is trademark. What exactly do those signs mean? Those symbols?
Yeah. Yeah, and they're both used in regards to trademarks. So anytime you see one in general, you know that you're looking at a trademark. If I see the little TM or if I see the R in a circle, you know that this is someone's brand, whether it's a logo or their name. A lot of times, you'll start recognizing it once you know what it is, way more often with, the companies that you interact with every single day. The biggest difference is whether or not you have a registration. The TM can be used at any point. It doesn't hold a ton of significant legal weight. Really, what you're saying there is the TM means this is my trademark and I am, asserting my trademark rights essentially, but it doesn't mean anything other than that. There's no requirement when you can or can't use it. Typically, my clients, I say, once you file, start using the TM in conjunction with your trademarks because you've established your trademark rights and you're going to start policing them as well. The Circle R, though, you have to have a registration, a granted registration in order to use it. So you can't use it just when you file, or you can't use it whenever you want. And so that's probably one of the biggest mistakes I see people use is that they'll start using the Circle R even before, communicating with me or before filing. And that's technically illegal. So always make sure you have a registration before using the Circle R. But that also means that it holds a lot more weight. It signals to your competitors and to the public that you have a registration, and that's a very strong protection. So that's why it's so important that they require you to have the registration to use the Circle R.
All right. Going back to the classes. So, what classes of goods or services should I choose for my trademark application?
Yeah, and it really depends, you need to look at whether or not, in general, are you performing a service or a good? And this really is, something that is a lot of times it can depend. Some people are performing multiple goods and selling multiple types of goods, and they're also performing multiple types of services under their mark. And that really is where, an attorney's advice will come in helping you decide what your goods and services are. But in general, if you're selling a product, look up what, the normal name in the industry of that product is, and you can determine what class it would fall in. Or if you're a service provider, if you're doing like installation or maintenance, or you're doing business services or marketing, you can look up those keywords and you can find out what class internationally your mark would fall in. And, depending on if you're doing multiple things on your mark, let's say I'm doing marketing services, but I also sell merchandise. So I also have a clothing store. I would probably file in both of those classes because otherwise I would not be protected in the class I didn't file for. If I didn't file in like clothing, but I only filed for marketing services, I would only be protected for my marketing services.
Nice, nice. But just to be clear, the same classes, this is like the classes, this classification, it is an international legal construct.
Mhm. That's correct. So For example, the international class for clothing is class 25. If I file in the US for clothing, I would file in the US for class 25. If I file in Canada for clothing as well, it will also be class 25.
What's the role of the United States Patent and Trademark Office, the USPTO?
Yeah, a lot of people think that the USPTO actually has a lot more power than it does. The USPTO, when you're filing for a trademark, only makes the determination as to whether or not you're getting a registration, but they can't tell you if you have to stop using a mark or how you should use a mark. There's also something called the TTAB at the USPTO, and that's the Trademark Trial and Appeal Board, and that's kind of like a mini court system within the USPTO for, when third parties want to contest with you over your trademark registrations or applications. But in general, if you get a trademark registration, the USPTO isn't going to do the work for you. They won't go out and prevent third parties from infringing on your trademark because that's not their job. Really, what they're handling is registrations. And so if someone else were to infringe on you and file for an application, they will prevent that application from registering, but they're not going to go out and sue that third party for their, in unlawful use of your trademark. That's always going to be on you. And so really the USPTO only is there to determine whether or not you're going to get your registration and the maintenance of those registrations. But it's up to you and an actual court system to decide whether or not someone's infringing on you and to take action accordingly.
All right. Which territories should I apply for trademark protection in?
Yeah, so really the most important countries that you're going to want to file your trademarks in are going to be the countries that you know specifically you're going to conduct business in. A lot of times that's going to be where you're living, or if you're doing e-commerce, most of the time you start with the United States, just because that's where the majority of that e-commerce is going to happen for a lot of people. There's no point in filing in a country that you know specifically your business is not reaching. So a lot of times with the internet and selling online, it can really cross the globe quite quickly. But unless there's a big customer base in some random country in the middle of nowhere, there's no point in spending the money to file for a trademark there. So in general, look where your customer base is, look where your sales are happening, and determine based on that which countries you want to be protected in case someone were to infringe you in those countries. So a lot of times those are going to be your biggest commercial countries.
That makes sense. How long do trademarks last?
Yeah, so again, let's start with the US. In general, they are indefinite if you maintain them properly. They do have to be renewed though, so once you get a registration, it's not just going to exist forever. The USPTO is going to want to make sure that you are continually using your mark in commerce, and that's one of the requirements for renewing a trademark. But in general, if you file a trademark, the first time it lasts for 5 years. So you have a renewal window between the 5th and 6th year after getting your registration. After that, it's between the 9th and 10th year. So another 5 years after that. And then after that, it's every 10 years. So in general, just think of it like your renewal is going to be every 10 years. But the first couple times it is a little more often, every 5. But if you properly file your renewal applications, your mark will exist indefinitely, technically. The renewal really is quite simple. It's just to make sure everything's up to date, to make sure you're still using your mark in commerce and all of that.
How does that apply to inheritance situations?
You mean if someone inherits a mark from like a deceased parent or something like that?
Indeed.
Yeah, so really that's just going to be making sure that the chain of ownership is correct. But let's say like I had a parent who owned a trademark and they, passed away, and then I inherit that trademark. Since I mentioned at the beginning of this video was that a trademark is an intellectual property right. So since it's property, that actually means that I would just inherit it like any other piece of like physical property from my parent. But at the USPTO, you would just have to let them know that you're inheriting this and that the ownership is going to change. And so, for example, you could let the USPTO know by, submitting a death certificate as well as an assignment, basically saying, I, am the inheritor of this property right from my deceased parent. And so now there's this updated owner, and you really just let them know that the specific facts. It's a bit similar to when you're transferring ownership. So let's say we're not talking about inheritance here. Let's just say I'm selling my business. If I'm selling my business, I just have to sign my rights to the new owner. And then you submit what's called an assignment agreement to the USPTO, basically saying, I used to own this, but I'm signing it to this new owner and now they will own it. And that's about it.
All right. Thanks for that. That is a lot of useful information. I'd like to ask about auditing registrations, where owners must regularly prove actual use of the trademark for all
Mm.
listed goods and services. So, how do these audits help ensure compliance, and how does one approach conducting them?
Yeah, so an audit is something the USPTO is doing much more frequently now. What an audit is a renewal application check, essentially. Normally, they don't look, they wouldn't in the past have looked too hard at renewal applications. Let's say in a hypothetical example, I filed a trademark for shirts, shoes, and hats. And then at my renewal window, they want to see, they want to make sure you're still using your mark in commerce, which means that I have to submit proof of use for my class. So for class 25, let's say for my renewal, I just submitted a picture of a t-shirt. Normally that's fine because you only need one proof of use per class. So I submitted a clothing proof of use. I submitted a picture of a t-shirt. An audit, though, is, they randomly will check applications for renewals to make sure that every single thing in your description is accurate and current. And so if I got an audit on that application, they would say, you showed proof of use for your t-shirts, but you haven't shown your proof of use for your shoes and your hats yet. And so an audit will say you either need to delete those goods or you need to show proof of use of them. And so if I'm not selling shoes, I have to delete them. If I am selling hats, I should just show proof of use of it, and then that part of the audit will be, complied with. And so an audit in general is the USPTO's way of kind of randomly looking at renewal applications and ensuring that every single thing within your description is accurate. And so most of the time that's for goods, just to make sure that you're not trying to get protection for goods that you're not or have never sold or don't sell anymore. And that's because, they want to make sure that your description is accurate because there's so many people trying to get trademarks that they want to make sure everyone has a fair shot at it.
Andrea, thank you so much. This was a lot of great info for me, our viewers, listeners, and our prospective clients. So thanks, and see you soon.
Yeah, thank you so much. And yeah, it was lovely talking to you. And yeah, if anyone ever has any questions about trademarks, they are a lot more complicated than they are on their face. So always make sure, you're consulting with a professional. And if you ever need any help, reach out to someone who knows.
Protect your brand with Trademarkia. Register your trademark on trademarkia.com.